quite shocking that something that the law is permitting, why are people feeling the need to come and seek permission from court, and why are courts not asking why have you come? Instead, they are looking at the case and giving permission or refusing permission, etc.
What has suddenly changed exactly after 20 weeks? That now suddenly after 20 weeks, you find unmarried women trying for a termination of pregnancy, so abnormal or so obnoxious or so wrong that you should disallow them from terminating the pregnancy. According to me, it doesn't fit any logical standard. Very recently in 2021, the Medical Termination of Pregnancy Act has been amended. Of course, because of relentless number of cases that we happen to do, that is Nikhil Datar versus Union of India. That's my case, which is still pending in the Supreme Court, and series of about 300 odd cases, which ultimately caused an amendment to the law. A lady who came to me, she was nearly about 24 weeks pregnant. Her fetus had multiple significant, very grave cardiac abnormalities, but in spite of multiple surgeries, treatments, etc., the child's quality of life would have been very bad, and probably child would have died in just a few years. So when we explained this kind of a prognosis, the woman said that I don't want to carry this pregnancy, I want to terminate this pregnancy. When therapeutics have improved, when termination of pregnancy can be done very safely, a lot of people think that termination of pregnancy requires to be done in some surgery or surgical manner. Actually, that's not the case. Today, there are such potent medications available which induce the process, something like a process of delivery or labor, where uterus contracts and the fetus is kind of expelled out from the natural passage. Now, when such fantastic treatments are available, it is obvious that the law of the land has got to change.
The law, in spite of having been amended in the year 2020-2021, much after the Supreme Court has spoken about the right to privacy and has included a woman's decision making on what happens with her body as part of her right to privacy, much after the Transgender Act, much after the Disabilities Act, the law is still not using rights-based language, which is quite unfortunate.
This particular amendment has, although on one hand liberalized the termination of pregnancy from 20 weeks to 24 weeks, on the other hand, this liberalization is available only for certain grounds, not for everybody and anybody. Women who are rape survivors, women who are minor rape survivors, women who are divorced or who have become single or widowed during the pendency of pregnancy. And that's it. So anybody besides these cannot terminate the pregnancy beyond 20 weeks. Termination of pregnancy at 24 weeks or whatever it may be, medically is absolutely not so very hazardous. And it is very safe to do. The amended law itself primarily is violative of women's rights.
Bringing in aspects like married, unmarried, the marital status of a woman should not make a difference to the fact that whether she wants to continue a pregnancy or not.
You are saying that the woman has to be a divorcee or she has to lose her husband in the pendency of the pregnancy. What if at all suppose she is not getting along well with her husband? The divorce proceedings are on, but still she is not a divorce. Now in such a kind of a scenario, is a pregnancy going to halt for her divorce to happen? And what has marital status got to do, with termination or no termination of pregnancy? I fail to understand completely.
So in a literal interpretation of the provision, yes, the court was right in saying that an unmarried woman is not covered. However, there are umpteen number of judgments from the Supreme Court, from various high courts, including the Delhi High Court, division bench of the Delhi High Court, single judges of the Delhi High Court, where in spite of what the law is saying, and this is even before the law was amended, even their permissions have been given considering the case of the petitioner before the court. Any minor who's pregnant, she will be considered a rape survivor, or that pregnant person will be considered a rape survivor. But the fact that there's mandatory reporting in POCSO has ensured that either the minor does not want to take service from a safe and legal abortion service provider because either the minor or the family does not really want to get involved with the police, or sometimes the service provider does not want to get involved with the police. The conflation with POCSO is still not ironed out.
Now, we have had occasion of seeing 11 and 12 and 13-year-old girls where they don't even understand that they are pregnant. I mean, the first ever case that we did a long time back, she came to us at about 26 weeks, and by far and large, these young girls, I mean, their parents find out that something is wrong, and by which time they come to us, they've already crossed 24 weeks cutoff limit. Courts, and many of them, Supreme Court and various other high courts, have allowed termination of particularly minor rape survivors right up to 32 weeks of pregnancy. But this new law again is restricting minor rape survivors to terminate the pregnancy. It's a health hazard to them. So why are we trying to tell them to go through that health hazard? Medical Termination of Pregnancy Act, and more particularly the rules under the Act, are so funny. It says that at no other place except the consent form and the register, woman's name should not be written. If you write it, it is considered to be violation of her privacy. If I am prescribing medications for a lady for termination of pregnancy, will it not be fair for me to write the name on the prescription? Now, if I don't write the name, will it be honored? Then I am on the wrong side of the medical council. If I write the name, that means I have violated the privacy. Now, if you put people in such kind of scenarios, then it is best for a gynecologist or a doctor to avoid doing a termination of pregnancy. So these are very great flaws in the amended Act.
In a country of billions, we've had 600 or 700 cases which have gone to court. So just think about the number of people who may have wanted to terminate a pregnancy but were not able to, and did not have the resources to go to a court, and would have probably ended up either giving birth or accessing some kind of a termination which may not have been safe for either themselves or for the fetus that they were carrying, or for both. It needs to be something that is broadly available to everyone as a right, so that the courts are, and frankly, why should anyone have to go to court to take permission for something so personal? And also, are the courts really understanding all of this? They are expected to look at only the law, and they are expected to interpret only the law. So it is also a big burden on the court to take a medical decision.